Our next presenter is Nicolas de Sadeleer. He'll be talking about climate legislation and litigation in the EU. We've had a presentation now on climate legislation in primarily California, and the one we just had from Michael Gerard on climate litigation in the US. So Nicolas is going to talk about those same sorts of things in the EU, which is, I don't know, the area that's kind of most similar to the United States. So he's EU Jean Monnet Chair at the Université de Saint-Louis Law School in Brussels, Belgium, which is EU capital. He's an expert in EU environmental law, having published a dozen or so books on environmental law in a number of languages. He speaks all kinds of languages, and including EU environmental law and the internal market through Oxford University Press in English. He's also published hundreds of articles in law reviews and edited books. So take it away, Nicolas.
Yes, is the sound correct?
Yes, we can hear you.
Perfect. Yes, I shall cut a long story short. Today, a number of proceedings are initiated before domestic courts as well as the EU General Court regarding the absence of actions or the rather intermediate or low level of actions regarding abating emission of greenhouse gases. There is a pending case in Belgium, pending for 3-4 years regarding linguistic issues. 2 days ago, the Norwegian Supreme Court, the Domstol, granted a leave to appeal regarding the Greenpeace proceeding with respect to the low level of actions of the Norwegian state authorities. A few months ago, the General Court of the European Union dismissed the Carvalho case, the case lodged by a number of farmers across the continent, contending with the rather low level measures adopted so far by the European Union. The case was dismissed regarding the standing of the farmers and their families on the grounds that they were not directly affected, they were not singled out by the EU acts that were challenged. This morning I shall focus on 2 landmark cases that were subject to much discussion in Europe. Firstly, a case decided by the Hoge Raad, which is the Supreme Court in the Netherlands, that was decided on the 20th of December 2019. And secondly, a judgment that was handed down by the Court of Appeal in London, divisional civil division, regarding the extension of the airport of Heathrow through the granting of license of a new runway. I shall spend more time on the Dutch case on the grounds that it's embedded on fundamental rights, an issue that was not addressed, I imagine, by Michael Gerard when he commented the different American cases. Environmental concern have been progressively incorporated into the interpretation of the first generation of human rights, and in particular the right to life and the right to respect for private and family lives. So these 2 rights are enshrined in the 1950 Paris Convention on Fundamental Rights. These provisions have direct effects. It means that domestic courts are required to implement them, and Accordingly, domestic court can nullify, can quash national measures that do breach this fundamental right. For a number of years, there's been controversies regarding the application of these fundamental rights to climate change issues. Climate change issues can be distinguished from traditional technological or industrial risk, both due to the temporal unpredictability as well as to the collective nature of the harm these risks are liable to cause. Indeed, climate change issues are permeated by uncertainty. Scientists are unable to determine with precision the regularity, the frequency, the magnitude of the possible impacts, irrespective of the quality of their models. So the impacts of climate change are likely to vary from California to Belgium regarding the time of latency, the speed at which the damage will occur, the frequency of natural events, their duration, their magnitude, their localization, their effect, and their scales. So I come to the dispute opposing an NGO, Urgenda, a Dutch NGO, and the Dutch states regarding the efforts that the Dutch authorities are called on under international law and EU law to undertake in order to abate the greenhouse gas emissions. The bottom line, it's a 2007 report drafted by the IPCC, the Intergovernmental Panel on Climate Change, that recommended the industrialized states, among which the Netherlands, to reduce their greenhouse gas emissions by 2020 by between 25 to 40% compared to the emissions recorded by 1990. The aim of that threshold, reduction by 25 to 40%, is to avoid reaching or exceeding a threshold of 450 ppm CO2 in the atmosphere. The exceedance of that threshold entails the risk of an increase to 2 degrees Celsius above the pre-industrial level. And the Paris Agreement of December 2015 place this threshold as the maximum that cannot be exceeded. So on the one hand, the claimant, the NGO, called for the implementation by the Dutch authorities of a 25% reductions, contending with the Dutch state authorities' approach that considered that under international and EU law, they were allowed to achieve a 20% cut instead of the threshold 25-40% that was recommended by the IPCC in 2007. So the whole dispute that had to be decided by the Court of First Instance, the Court of Appeal, and finally last December by the Supreme Court, revolved around the difference of 5% between the projected reduction of 20% decided by the Dutch government and the claim put forward by the Dutch Urgenda NGO that the Dutch authorities were called on to reduce the emissions by minimum 25%, the optimal being the 40%. Of importance is that the Hoge Raad, the Supreme Court, dismissed the appeal of the Dutch state authorities that were already condemned by the Court of Appeal of Den Haag on the ground that the Netherlands is subject to a duty of care obligation stemming from the right to life and the right to privacy that are enshrined in this Paris 1950 agreements on fundamental rights. These provisions have direct effect. Accordingly, the Dutch authorities are required to adopt mitigating measures reaching the minimum 25% reduction by 2020 compared to the emissions amount accounted for 1990. That threshold is replacing the projected governmental threshold of 20%. So the whole case is about significant effort to shift from the initial governmental threshold of 20% up to a threshold of 25%. So that requires, for the end of this year, significant effort regarding controlling transportation, controlling urban sprawl, controlling port emissions or industrial emissions. So I'll move into the hardcore of the judgment that could be of interest to Americans because it's exposed very different visions than the vision exposed by American federal courts. The Supreme Court recalls, first of all, that the state authorities are subject to positive obligations under the two human rights provisions. Well, that means that they have to take actions in order to preserve the right to life as well as the right to family life. The court has been dismissing the narrow interpretation put forward by the state authorities of these two provisions. Regarding the personal scope, the court is claiming that the protection warranted under these two provisions apply to society or population as a whole that is threatened by the environmental risk stemming from climate change. So as a matter of fact, the two provisions do not apply, as they've been applied so far by a number of courts, exclusively to individual natural persons. It means that fundamental rights do encompass communities in the Netherlands that are at risk because of the sea level rising. So this is a landmark development regarding the human rights case law. In that connection, the Supreme Court is stressing the vulnerability of these communities that are exposed to sea level rise. One has to bear in mind that 1/3 of the Netherlands is under sea level. It's protected so far by dikes. These dikes are actually reinforced to avoid severe floodings due to sea level rise, but the whole process is still encumbered with a high level of uncertainty. Regarding the timing of the action, the High Court is taking the view that this positive duty of care applies when the risks are real and immediate. That was contended by the attorneys of the Dutch states, claiming that the court has to demonstrate that the risk was immediate, that the risk was going to take place to occur in the 6 or the 10 coming months. The High Court is dismissing that argument on the account that immediacy of the occurrence of risk must be differentiated from the immediate risk. And so the immediacy of risk can encompass risk that can occur in 5 years or in 10 years or in 20 years from now, risk that can impact upon forthcoming generations, in as much as these risks are tangible and direct. Is it okay? Yes, okay, I continue. Regarding the substantive scope of the positive action, the High Court is taking the view that even though there are still doubts about the specific manifestation of this risk, the preventive measures must be adopted in order to belittle the occurrence of this risk. As a result, being based upon this scientific consensus of a risk of severe impact on the Dutch territories, impact that's likely to affect the life of millions of individuals residing upon that territory, the court is taking the view that the Dutch authorities are subject to these due diligence obligations. It means that the policy must be coherent and timely. The measures taken by the authorities have to be reasonable and adequate. These measures are subject to judicial review on the account that they are entangled with fundamental rights afforded to the Dutch communities. What is more, is the court is claiming that the state bears the burden of proving that its policy is adequate, reasonable, coherent, and timely. The Supreme Court is also reckoning upon the principle of precaution, a principle that is enshrined in a number of legislations across Europe, and which has been dismissed by the different US administration. And I imagine after the talk of Michael Gerhardt, that the Trump administration is taking a dim view on the principle of precaution. So the Supreme Court of the Netherlands is taking the view that even though there is still lingering scientific uncertainty regarding the exact nature of the risk that may have an impact upon the Dutch communities, the Dutch authorities are not relieved of their positive obligation to avoid the realization of that risk. I quote, there is a tangible possibility that such a risk may manifest itself, and that results in a requirement to take appropriate action to avoid the occurrence of the risk. Too flexible a policy is likely to breach, to run counter to the principle of precaution. So this is, again, in that connection, the judgment can be analyzed as really a landmark judgment on the account that many other Supreme Courts in Europe have been taking rather cautious approach with respect to precaution. So I will list three arguments that were put forward by the claimant, the Dutch authorities, and that were dismissed by the Supreme Court. Firstly, the Dutch authorities claimed that the 2007 report was outdated. It was superseded by a 2015 report, and that the dividing line drafted in the 2000 report between the industrialized countries, among which the Netherlands and the other states, has been blurred due to the breakneck industrialization of developing countries, among which China. That argument was dismissed on the ground that the Dutch authorities were obligated to carry out positive measures in order to award full respect of the fundamental rights. Other arguments is that the phenomenon is global. The USA is actually emitting much more greenhouse gas than countries like Belgium or like the Netherlands. That argument was dismissed for the same reasons. Third argument is that the 25% cut favored by the litigants by the Urgenda Foundations will enable a global reductions of the increase of greenhouse gas by only 0.0000.45 degrees Celsius. That means that the shift from 20% reduction to 25% reduction for the end of the year, by the end of the year, will entail limited benefits for the planet. And these benefits were totally disproportionate, having regard to the additional cost placed on the Dutch authorities and the Dutch economy. That argument with respect to proportionality was also dismissed on the ground that the Dutch state is required to comply with its international obligation no matter the low impact of its domestic policy. Finally, two other arguments were dismissed. The Dutch authorities claim that the High Court of Appeal gave them an order to legislate. Solely the legislator can decide whether or not to enact legislation and decide the content of the legislation. So I imagine it will be the same reasoning under US law. The Supreme Court confirmed that it was not an order to legislate, it was just a declaratory ruling of unlawfulness on the ground that the Court of Appeal just decide that the statutory approach was insufficient to afford due respect to the fundamental rights. And so by no means the Dutch court order to the Dutch lawmaker the precise content of the measures to be enacted in order to reach the 25% reduction threshold. Similar arguments is related to the principle of separation of powers. I imagine that also under US constitutional law you are tackling with the same principle. There, the Supreme Court took the view that the protection of fundamental rights is an essential element of a democratic state governed by the rule of law. So all in all, these judgment opens up new perspective on the scope of two fundamental rights, right to life, right to privacy. In particular, the court makes reference to the precautionary principle. Irrespective of the Dutch state contribution to the global phenomena, the Dutch authorities are required to shoulder their responsibilities. So I imagine that from different angles, from different perspectives, one is dealing with a landmark case. The second judgment that was handed down a month ago by the Court of Appeal in London has been widely commented in the British press. The Divisional Court concluded that the British government policy in favor of developing a third runway in the airport of Heathrow was produced lawfully. So one is perhaps aware in California that the Heathrow Airport is a major international hub. This is the busiest airport in Europe. Each year it handles about 70% of the UK long-haul flights. 80 million passengers using that airport a year. And in order to maintain its international status, the UK government was eager on developing that airport in granting consent in favor of the construction and the operation of a third runway instead of investing in other regional airports. So the issue is a bit somewhat complex, but I will recall 4 stages. Firstly, the Climate Change UK Act of 2008 provides for a carbon target by 2050, amounting to a reduction of greenhouse gas by 80%. So it's not the Dutch target for 2020, it's for by 2050, and the target is much more ambitious. That target has been replaced a year ago by a full carbon neutrality that will apply by 2050. Secondly, in 2016, the State Secretary for Transportation claimed before Westminster that there was a need to develop a new runway at Heathrow, and that decision was followed by the ratification by the UK of the Paris Agreement on the 17th November 2016. So a month after claiming before Westminster of the need to extend the capacity of Heathrow, the UK government ratified the Paris Agreement. And somewhat a year later, on the 26th June 2018, the British government adopted the Airport National Policy Statement, endorsing the willingness to develop Heathrow Airport. What matters in this case is not climate change litigation, it relates to land planning litigation. And that could be, I imagine, of interest to many Californian lawyers. Under the Land Planning UK Act, the national policy statements with respect to agriculture or with respect to transport or to air transport must include, according to section 5, paragraph 8, the reasons giving an explanation of how the policy set out in the statement takes account of policy relating to the mitigation of and the adaptation of climate change. So the Land Planning Act provides for expressly the obligations to state the reasons in the national policy statements as to the manner in which climate change mitigation and adaptation is likely to be integrated into the statements. So the litigants put forward a number of claims regarding the breach of nature protections obligations stemming from EU law, environment impact assessments obligation, and so on and so forth. All these pleas were dismissed by the Court of Appeal. However, with respect to the statement of reasons stemming from the Planning Act, the Court of Appeal decided in favor of the claimants, different NGOs, different residents, and the Court of Appeal was taking the view that there were no references whatsoever in the airport national policy statements of the Paris Agreement. There was some reference to climate change issues, but the Secretary of State did not make reference whatsoever to the Paris Agreement, although that agreement had been ratified in 2017 by the UK government. So in the Court of Appeal's view, there is a requirement placed on the Secretary of State to act in accordance with the Planning Act and to state the reasons, among which the correct implementation of Paris agreements that provide for much more ambitious targets than the target that was enacted in 2008 under the Climate Change Act. So the court is at pain in explaining that they don't want to rule as to whether there is an opportunity, it's wise or not, to build and to operate a third runway. This is a matter for politicians that escape the review, the judicial review. The court is just at pains in explaining that the Secretary of State must state clearly the reasons of operating that third runway with respect to the Paris Agreement ratified by the UK government. Of course, the case is highly politicized on the ground that the PM, Boris Johnson, was against granting consent to a third runway. So the the judgment has been quite favorable to the today's government that want to create more economic opportunities for more regional airports and to avoid the congestions at Heathrow airport. So
Nicolas,
yes.
you're out of time. So if you could wrap up pretty quickly, that would be great.
Great. I was always afraid to be too short.
I know.
To conclude with the two judgments of interest from a comparative legal perspective analysis. The first one really broadening the material, the temporal, and the personal scope of two key fundamental rights provisions. The second case is also of interest regarding the obligation to clearly state the reasons with respect to the policy agendas regarding the abatement of greenhouse gas emissions. Thank you very much indeed.
Thank you, Nicolas. That was a great presentation. One of the things I like most about hearing from the EU is that there are all kinds of ways in which they're doing things differently that we might consider adopting to the degree we can here. You know, for instance, human rights as an important, you know, greenhouse gas like cause of action, or the precautionary principle, which is somewhat, I think, soft law in EU, but is definitely not, you know, juridical. It's not something we can use for any kind of litigation for legal claims here. Also, the Paris Agreement. We'll see this in a case I'll talk about in my second presentation later, but as kind of a legal authority that you can base something on. We can't do that really very much, at least in the United States. So I think that was very illuminating, and you know, thank you so much, Nicolas.